Welcome, everyone. I'm Lisa Esquivel-Long, editor of KPC Media's Greater Fort Wayne Business Weekly, and I'll be your moderator for today's webinar. This is the latest in a monthly series that we're bringing to you free to subscribers. The topic of today's webinar is a follow-up to one we had a few months ago, and we all know how fast things can change in today's world. Today, we are bringing you the changing landscape of data security and privacy with a presentation not only by Barrett McNagny, but also digital design firm JH Specialty. We want to hear what you're concerned about. So during today's webinar, please ask your questions by going to the Q&A section, not the chat, but the Q&A section that you'll find on the right-hand side of your screen. We'll go over your questions periodically throughout the presentation. Here with us today are Justin T. Molatoris of Barrett McNagny and John Henry III, owner of JH Specialty. Welcome, Justin and John. Please tell us a little bit more about your background and what we'll be discussing today. Let's start with Justin.
Thanks, Lisa, and thanks Greater Fort Wayne Business Weekly and everyone who's tuning in this morning. As Lisa said, I'm Justin Molatoris. I am a business attorney here at Barrett McNagny. We're a full-service law firm located here in Fort Wayne of about 50 attorneys. From a business perspective, we do everything from startups all the way to work with Fortune 500 companies. My practice itself is a nice mix of mergers and acquisitions, privacy compliance, and software and technology licensing. That's what led to this presentation today and the one a few months ago. I'm a CIPP US, which is a certified information privacy professional, certified by the International Association of Privacy Professionals. Essentially, that means I have a strong understanding of the United States privacy laws and how that will impact businesses on a day-to-day basis. John?
Yeah, thanks, Justin. My name is John Henry. I'm the principal of JH Specialty. I had the pleasure of starting the company in 1998. Today, our team is approximately 50 people. We help CEOs and business decision leaders in mid-market companies, typically providing solutions with a marketing or technology spin, helping anyone from becoming more efficient, gaining new customers, and then also being compliant and safe while doing those things.
Today, we're going to take a high-level view of privacy laws, both from a privacy perspective and a data security perspective, and slowly bring it down to a more granular view where we can look at specific basic compliance components, namely website privacy policies and internal privacy programs. Before we get to that, simple disclaimer, this is not legal advice. This does not create an attorney-client relationship. Everybody's situation is unique. So please do not rely on this presentation as legal advice and reach out to counsel for any specific questions related to your organization. I wanted to start by addressing from a broad view, concepts of the fair information practices. Now, there's a longer list of these. I boiled it down to 4 categories. These are the traditional concepts of fair information practices. They start with rights to the individual. So rights to the data subject, things like notice of data collection, the individual's consent to that collection and use of the data and their access to the data that has been collected about them. Another category is information controls, security and the integrity, how we protect the data and the information we collect. Then we have information lifecycle, the timing of how that data comes in, where it rests, how we process it, how we use it, and then ultimately how we terminate it. And then finally, information management. How, as an organization, do we manage our data collection system? How are we monitoring our employees? What policies are they following? What practices are they doing? Now, like I said, these are very traditional concepts, and today they're changing. You know, from a broad view, they're all there still, but even more so from a day-to-day basis, the focus is on the rights of individuals. And we'll see that both from legislation that is currently being reviewed at the state and federal level, and also state laws that have been enacted, namely in California, in Virginia, that really emphasize the rights of the individual. Before we go further, I did want to touch on you'll hear terms of privacy and data security often in this world. They're related, somewhat different. Privacy itself is more so related to, again, the rights of the individuals, how we are handling their data, what they know about it, those sorts of things. And then data security is, from an organizational front, how we're protecting the data of individuals that we're collecting. So again, these are often interrelated. There's different legal frameworks that address both, sometimes together, sometimes separately. But there's two separate avenues really to get at the same thing, which is to prevent the unauthorized disclosure of a data subject's personal information. The United States privacy law framework itself is not uniform. All right, it is a patchwork quilt at best. It's different from Europe, where Europe has one real governing law that relates to privacy rights of individuals and how organizations have to treat privacy. In the US, we have to look at a number of different levels. So we start with the federal, then you look at the state, then your industry standards, and then contractual obligations. So from a federal level, there is no one singular law related to privacy protection and data security. That could change in the future. There is a law that is a bill that is being entertained by Congress right now, the American Data Privacy Protection Act. It has some momentum, but obviously there are forces on both sides, whether or not it goes through as drafted or it's amended significantly. But it does tell you that this is on the radar of federal legislatures. The idea is, from a federal perspective, we want to minimize the amount of data that businesses are collecting and increase the standards of protections related to the data that is there. But the current lay of the land is there are federal laws related to specific industries. A few are named here. There's the Gramm-Leach-Bliley Act, which is in the financial sector. So you think banks, credit unions, insurance companies, financial advisors. Health sector, all of us, we've heard of HIPAA, the Health Insurance Portability and Accountability Act, as amended by HITECH. Educational sector, you have FERPA, the Family Educational Rights and Privacy Act, and then there's online activities. Online marketing is governed by CAN-SPAM, Controlling the Assault of Non-Solicited Pornography and Marketing Act. All of these have a lot of similar features. There's a requirement of notice. This is the type of data we're collecting. We are collecting your data. Here's how we're going to use it. Most of them expect an internal privacy policy, governing your operations, what your employees are doing, who accesses data, how they use it, how we terminate the data, and finally, annual testing and training. And you'll hear this throughout, but training is a lot. Just going through the steps of training employees on an annual basis does a lot to bring your compliance up to par. It really keeps this front of mind with employees and shows regulating bodies that you're doing the best that you can. And this last point under federal law, we'll touch on a little bit more detail later, but under the Section 5 of the FTC Act, the Federal Trade Commission has the right to enforce unfair and deceptive trade practices. And that has typically come up in this realm in relation to website privacy policies, which again, we'll touch on in more detail later. From a state law perspective, this is where a lot of the change is occurring and much more rapidly than at the federal level. So we are seeing some states pass comprehensive privacy laws. The first was California with the CCPA, which has since been amended going into effect in 2023 to the CPRA, the California Privacy Rights Act. What this is the most comprehensive, individual rights friendly privacy law on the land. It's right now the highest bar to meet. And so if you are conducting business that relates to data subjects in California, this is the bar you have to exceed. And this is really the target for any privacy program that you should have. As long as we're complying with CPRA, we're probably good with all the other laws in the land. Since the passing of CCPA, Virginia, Colorado, a few other states have passed similar comprehensive privacy laws, Massachusetts. There have been a number introduced throughout the nation. I think some 23 jurisdictions, including Indiana, have introduced bills that are now viewed as inactive. They went out of committee, but really didn't do anything on the floor. Ohio has a current bill that is being entertained, which is not as consumer friendly, but it does, increase the requirements for businesses that are doing work in Ohio. And then more specifically, Illinois has BIPA, the Biometric Information Privacy Act, which is unique in that it was passed 14 years ago in 2008. And then it sat there and you didn't really hear anything about it until it became a pretty plaintiff-friendly law from a biometric standpoint. We all have so many different devices that gather information on a daily basis. We all have smartphones, TVs, smart fridges, laptops, smart watches, tablets, iPads, all these things, cars, and they're always collecting data. And BIPA specifically relates to biometric data and grants a private right of action to an individual if one of these devices or apps or software is collecting this data in a manner that's non-compliant with BIPA. So again, it has been very active the past few years as a law that plaintiffs have bring claims under in Illinois. Next, we have industry standards, and we'll also touch on this one, the most visible one, a little later as well. But the Payment Card Industry Data Security Standard, PCI, it's probably the most prevalent industry standard relating to data collection and protection, and it particularly relates to the use of payment card processing machines and the information collected and transmitted by those. So if you are accepting credit card payments online or on premises, you are going to have to comply with PCI compliance. And the interesting aspect of this is that there are direct penalties related to non-compliance that can come from the organization itself. Whether it's, you can't access our system any longer, and so you are shut off from payment card acceptance, or fines as well. And lastly, we all have contractual obligations typically in this arena. It's becoming more and more common for contracts to impose obligations on service providers or suppliers, or even on the flip side on customer and clients relating to privacy law and your data security commitments. So there are typically two ways that these frameworks are inserted into contracts. The first is that you, as the service provider or entity, are going to develop your own commercially reasonable written information security plan, right? A lot of people will sign on to this contract and not even think about, hey, I have to go through and do that step. But if you don't have that in place, the moment you sign that agreement, you're going to be in breach of the agreement. So it will impose on you the obligation to have your own data security plan. The flip side of that is you, service provider, required to comply with my data security plan. And the reason that is troublesome, even alarming, is that you might have no idea what that security plan says. The requirements and obligations of it might go far beyond the scope of your relationship or your organization's means of complying with it. It could be a large organization that has set a bar so high that you don't need to meet, and frankly do not have the resources to meet. This is a rubric. We'll go to the next slide. Great. So again, we're going to move down to a more granular level and look at organizational compliance. And these are two basic components of compliance. And again, there are only two. This is low-hanging fruit, but it's something that essentially every organization should be doing from a compliance standpoint. We all have websites. We all have internal operations, right? And so we should have a website privacy notice, and we should have an internal privacy program. Now, before going further, I do want to touch base a little bit on a confusing aspect of this terminology. You'll often hear the term privacy policy, and that can refer to either the website privacy policy or the internal privacy policy. I like to try to split it out a little bit, and we'll call it a website privacy notice and an internal privacy program so we can avoid confusion. But even in contracts, you will see that term used interchangeably, and it's really important to understand the difference between the two. Our website privacy notice is, it's what we post online. We call it our privacy policy on our website, and that is public facing, consumer facing. And so they see that, and that's our promise and our commitment to what we're doing from a privacy standpoint. The internal privacy program is essentially an internal operational policy informing our employees, how we handle this sort of information, the sensitive data that we receive and collect, whether it's through the website or otherwise. It could be related to our own employees, things of that nature. So they're related. A website privacy notice is part of a privacy program, but you will see that privacy policy terminology used interchangeably. So again, related to the privacy notice, and I talked about the FTC's unfair and deceptive trade practice jurisdiction earlier. And this is where it really comes into play from a legal standpoint. The privacy notice, like I said, is consumer facing. It's a public facing document, and it's our commitment to what we're doing from a privacy standpoint with a data subject's information. And so from a legal standpoint, it actually creates or allegedly creates a contractual obligation, between you and those users of your website. All right. So you said you're going to do this one thing related to privacy, and then you don't do it. So you make a material misstatement or omission that might mislead these users as to how you were treating their data. Well, from an FTC standpoint, and this is also enforceable at the state level as well from states' attorney generals, this could be viewed as a deceptive trade practice. Relatedly, unfair trade practices have been viewed as not maintaining commercially reasonable data security practices. So if you are not meeting a commercially reasonable standard, typically this is egregious, you're not protecting data in any manner, that can be actionable as well. Now, this is also front of mind because the FTC just started a formal rulemaking process to get more detail around what qualifies as an unfair and deceptive trade practice in this area. The process is not quick by any means. This will take years to go through, but the notice itself is interesting because it really frames the concern as not data collection, but they call it commercial surveillance, right? And so we're moving from a world where, the data collected by businesses is their data and they use it as they need to businesses are collecting so much data that they are in fact surveilling the public. And it's a shift in that lens to a, that's a less innocuous term. Commercial surveillance, it signals something, and we'd anticipate that we'll get some more a greater framework around what is an unfair and deceptive trade practice, through this rulemaking process that hopefully is more definitive and likely more concerning. So, John, I'll turn to you from the basics of a website architecture and how that relates to the website policy and privacy practices of an organization.
Yeah, thanks, Justin. So I just want to cover, we're going to start with basics. What I say is, most people here have a website or an online identity. It may be a brochure site that's just telling information. You may be gaining a little bit of information through a contact us, or at least telling people how to raise their digital hand. Others may be in e-commerce, which we'll go in a little bit deeper as relates to whether that's business to consumer or business to business. So one of the first things that you can do, which is relatively new in the past 3 to 5 years, is typically if you had an HTTPS versus an HTTP, an SSL certificate, which started out to be that green bar, if you remember that in your browser, that was only if you were doing commerce. Well, that's changed by having HTTPS and having that SSL. There's a lot of security that you give your end user that prohibits things that other third parties may be able to do inside of a browser, even if their computer has a virus of some sort. That HTTPS, that SSL certificate, allows for a more secure communication. And there's also a benefit that allows that Google has even said it's important enough that they're putting that content higher in the search engine results. So that's something that, for the time and money that it takes to do that is well worth it, no matter what online identity you have. It also allows the individual, you see that little lock up in the browser, to click on that and to learn more about the organization, to make sure that it truly is your organization, that it's not someone who's spoofed a website or a URL that looks like you and has done that. Depending on the type of SSL, there's different verification methods that are related to that. So that would be something that would be dependent on how you're using that information. The other basics, the privacy policy, the terms of use, and other online disclosures. As Justin mentioned, you're setting an online contract, right? So little things like using Google ads for remarketing, those ads that you see, that you come to somebody's website and you're seeing that ad after you've left, that needs to be in your privacy policy or your terms of use. Google has specific language that they want you to have there. So that's very basic. Also, all the way down to, are you collecting information when they're there? Anything that's there to protect you and provide data on how you may be using information, utilizing technology such as cookies to represent information based on historical traffic that may have occurred. Hosting, maintaining and ensuring ongoing updates. Many of us probably remember when you got the $9.99 a month, HostGator or GoDaddy hosting. That's probably not cutting the bill anymore. You want to make sure that you really are operating, getting updates on your operating system, your server-side scripting languages, and your databases. So some of you may have, a very widely popular content management system is WordPress. Once you put it out there, that version has all those things buttoned up, and they give you a pretty good way to try to maintain, updating the WordPress is currently in PHP, updating your PHP version, updating whether it's Linux or Windows hosting. But that is something that you either need to actively do or have someone do on your behalf. Those who are trying to take advantage of the situation are looking for your weakest vulnerability, and that's one of them, right? That's probably why we have our security, and we can constantly have to restart our computers as we're doing those things internally as well. And why do we have to do this, even if it's just a basic online identity? Because it is your reputation and your trust. So again, as you go to somebody's website and all of a sudden you're seeing that ad that's following you around, you want to tell somebody that we were doing that and why you're doing that. The other thing is, if something does happen, and I recently saw it where an online, very large B2C e-commerce client that we have, or not a client that we have, but we are a client of theirs, they had a vulnerability and they sent out an email, which you clicked on that email, looked like a billing statement, and it put a virus on your computer, right? So how they got in, I don't know in this particular instance, but it is your reputation. And these are some of those basic elements that we would suggest that you're doing just to be on the surface level of making sure that you're moving and have a proactive method.
Yeah, and I just want to touch base on the privacy policy in terms of use a little bit more. You can get form documents online for that. However, these are very, like we're saying, these are contracts between your business and the consumer or user of your website. And so it's really important for that to be tailored to your organization. From a privacy compliance standpoint, like I said, if you're touching California users, there are very specific components of your privacy policy that your privacy policy must contain. A couple of them are, you have to identify by category the types of information you're collecting and how long you're retaining that information for. You have to give them somebody to contact when they want to enforce any of their rights that they have under the CPRA. And so those are very nuanced things that really should be in your privacy policy. And then on that last point on reputation and trust, yeah, there is, there's this regulatory and legal concern out there. But a lot of breaches don't rise to that level, and then some of them are so unknown that they're only known to you and your customers. And that really is the sticking point, right? If you have, the more data you have, the larger your world of risk. That's from a legal standpoint, but then also a business reputation standpoint. And one breach is extremely harmful to that goodwill.
So now as we build on that, right, e-commerce. So now there's a lot of different things that we're doing besides just giving information and asking for someone to raise their digital hand. So Justin mentioned PCI compliance. So in this world, there's a lot of different things that are there. There's a lot of things that are complete no-nos, and there's a lot of different ways that you can kind of spread that liability or leverage third parties to do things. So PCI compliance, one of the main things is that you are accepting payment online. So as you're doing that, as an example, one of the ones that could be detrimental as it relates to the fees that come along with PCI compliance is saving that CVV or that security code on a credit card. And realistically, in today's technology, there's no reason for a company to be recording and saving this information on their own in their own databases. Typically, there are online processors where they'll store the credit card information, and you can utilize technology known as tokenization. So you have a one-to-one unique identifier, so you can use that payment information in the future and not have to have that sensitivity, that sensitive information in your database. But it does go outside of just the database. You may also allow people to call in and give payment over the phone. What kind of policies do you have in place, those internal policies that were mentioned earlier on, can they write down a credit card information? If they do, how quickly do they have to get rid of it? Those different things that it's above and beyond just the platform that you're in. That sensitive data, I mean, the most sensitive and where you can get maybe the highest financial impact is the, where we're talking about credit card data. But there's other sensitive data. It may be their mailing address, if they have children profiles, if they have, birth dates, any of that, right? I mean, we're very sensitive to that. That's why you're seeing, the Googles and the Apples of the world creating additional privacy initiatives on their end, because the consumer is starting to raise their hand because of the surveillance that they feel like they're under. They want to know what kind of controls that they have. So just understanding that anything, as little as you may think it is, anything that you have about a person may be more sensitive to them than you may be thinking about. And then it really is, how do you provide convenience versus, with that convenience, the liability? That's where utilizing the right third parties, the right online payment processors to utilize things like tokenization allows the online consumer to have that ability to have stored credit card payments, profiles, addresses. So it's very easy for them to interact with you, but at the same time, not putting all that liability on you. So really talking with whoever you're doing e-commerce with today, whether that's internally or externally, to understand what tools are out there, what third-party integrations there are, to really just set the stage on what you're doing to provide the most convenience to your online user and reducing the risk or liability. As we talk about data storage and encryption, how you store data and whether that's encrypted or not is very important too. So things like passwords obviously should be encrypted, the way that you're passing even credit card information. So there's, talking about data at rest and data in transit, you want to make sure that that's encrypted to make sure that there's not anybody who can, grab that information unintentionally as you're passing this information. Or if someone gets to the point that they do get to your data, that hopefully the data is worthless at that point because of the encryption and the encryption keys that you have, they're proprietary to you. At that point where that's not what we want to happen, but if that happens, right, that the encryption is going to allow you to keep your customers' information still secure and not in the wrong hands. Which leads us to hosting infrastructure. PCI has a pretty robust, what they consider their best practices. Typically, that's going to have a physical firewall up front that's really investigating the traffic. Then you get to maybe a web head server, which is presenting the information to the online user. And then your data is actually behind that. And so there's a lot of different ways that you can create layers. So as those quote unquote bad guys are trying to get to the data, they have multiple hoops and jumps that they need to get to. And again, hopefully by the time, if they would get there, which is again a worst case scenario, you have the encryption to make sure that that's not something that they're going to be able to use. But the reason why I end this with customer password policies, and passwords is going to be something that continues to come up, is it doesn't matter how robust your policies are if you're not, empowering or educating your online user to have a good password, right? Because if someone comes to your website and somehow there's a fraudulent charge that happens on your e-commerce website, that automatically looks like that's going to be your issue. And you're going to have to defend, justify, and explain as it relates to that. That weakness may be the password. So, really, when you look at things, how often are you asking your online user to update their password? Are you looking at online tools that talk about data breaches or the top used passwords and educating your online user? And there are other things that you can do, again, to spread that liability. Use things like, log in with your Google profile, your Facebook profile, your Amazon profile. As consumers do want to continue to have this convenience, but are becoming less and less maybe likely to continue to pass their information around, think about these other ways that you can, again, increase the convenience of doing business with you, but not increasing your liability at the same time.
Yeah, and we were talking yesterday about common passwords, and one that I read in an article recently is that as people are required to change their passwords, often 30 to 90 days, a common password is season year plus exclamation point. So the current password would be summer 22 exclamation point, and next password would be fall 22 exclamation point, so on and so forth. And that kind of predictability within passwords is just a weakness that it not only impacts the customer, but can impact your system as well. This page really lends itself well to the internal privacy program, right? We're setting out our practices in relation to our website and how we're going to handle the data. The one point I wanted to touch on is, every jurisdiction, every state has a breach notification law. And so to the extent that if we ever did have an event that would rise to a level where we would have to provide notice of a breach, encryption itself can be an exception from that requirement. So if the data at rest is encrypted and the encryption key was not accessed by the bad actor, well, then you in fact don't have a breach, right? They can have as much encrypted data as they want. If they don't have the key to unencrypt the data, then there's no disclosure there. So those internal practices can really mitigate risk in the event of a bad actor. Now, we talked about how the fair information principles are shifting more towards rights of users, and we're seeing that on a state-to-state basis. A lot of these comprehensive state laws include very common rights to the individual data subject. We talked about first, the first one was notice. You have to tell them you're collecting data. You have to tell them what data you're collecting, how you're using it. So they have the right to know that sort of thing. They have the right to ask for a copy of the data, right? That, what do you have about me? What does it say? And then they have the right to correct that. They say, well, that's wrong. You need to update it. This is very similar to, requirements from the Fair Credit Reporting Act. If there's something that shows up on your credit report that's incorrect, you have the right to dispute that, and the credit reporting agencies have to update that. Some of these laws give the right to be forgotten, where individuals can ask that their data be deleted. And they also have the right to portability, so they get a full copy of their data in a format that they can use, things of that nature. Now, specifically in relation to websites, there's the concept of opt-outs and opt-ins. And so an opt-out is, the user taking the affirmative action to say, you can't use my data in this way. So until they take that action, you have the right to process the data in that manner. The opt-in is the user taking the affirmative action to say, you can use my data in this way. One of the common occurrence here is the difference between adult users and juvenile users. And so for adult users, when it comes to targeted advertising, things of that nature, it's typically an opt-out. But when it comes to the juvenile users, the guardian has to affirmatively opt in for that sort of thing, as well as downstream sales of data. So if we collect data and we sell it, those things are subject to opt-out and opt-in. And John, from a constructing the website perspective, how are you seeing opt-outs and opt-ins used, and how do they come up?
Yeah, so we talk a lot about raising your digital hand and then taking and bringing your digital hand back down, right? And a lot of those conversations are still built on the golden rule of treating others how you want to be treated. So typically it's either in email and text, and SMS is something that's becoming more and more prevalent online. So, just think about during the checkout process, if you opt in or opt out of future marketing emails that you want to get. Some people automatically have that box checked as you're doing things. Others are asking for that, right? So obviously as a business owner, you're thinking, I want to get as many email addresses as I can get. But is it quality or is it quantity? Probably somebody who's opting in for that information is going to be more deemed to use that information because they see it as something that they want to get. Also, the CAN-SPAM Act that was previously mentioned wants to make sure that that's something that you can opt out of, right? So even if you are in an email program and you're getting that at the bottom, you have to have either a one-click unsubscribe or the ability to unsubscribe from multiple lists. The other thing that from a practicality perspective, when you talk about email, is it's not only that unsubscribe inside of your email through the email provider that you have today. The Googles, the Outlook 365s, they all have a unsubscribe button of their own, which is actually a complaint that is put in about your organization. That actually impacts emails that come from your organization, whether it makes it to the inbox or how it's flagged. So these are things not only from a compliance perspective, but the ability to leverage these mediums. SMS, text, which is becoming more and more part of the online experience. Maybe you want to get notices via tracking for when your package is going to be delivered is a big one, or just opting in for future marketing messages. This still goes back to the mentality that people thought that they had to pay for these, right? So making sure that when you have that stop, that you can click stop, opting in after you send the text message, as opposed to just having it. So, Many times you probably see that you say, yes, I'd like to know when this shipment is going to be delivered, which then automatically you get a text message that says, do you want to subscribe to future notifications to do these things? So there's best practices in all of these things that we do always look from a legality perspective and a golden rule perspective on what's going to allow you to have the best conversation, because that's where we're going, right? Is how do we get to a one-to-one conversation with your end user, whether that's into a B2B space, a B2C space. That's where we're seeing the biggest impact. And so leveraging things like that to get there.
Yeah. And from a privacy standpoint, these rights are things that are constantly changing. So I know I touched on state laws earlier. We can look at it this way. California passed the first comprehensive state privacy law in, I think, 2020. And it was a high bar, and the law, that was the framework that other states were going to follow. They have already passed amendments to that and improved or changed that law. There are, I think, 4 new state laws going into effect next year. Some going into effect January, some July, one December 31 of 2023. And so this landscape itself is constantly shifting. And then there are 2 special categories I do want to touch on here for the rights of users. And that's if you are, you're touching data outside of the US, if it's coming in from Europe or from other areas of the globe, you're really, we're talking about raising your digital hand. You're raising your digital hand to those jurisdictions that you're now doing business with them, and you could fall under in Europe, the GDPR. United Kingdom has their own separate version of that, very similar, and they're bodies that are very aggressive at pursuing compliance with their privacy frameworks. Privacy has been front of mind in Europe for a longer period than it has been in the United States, and the rights to the individual are higher. I think California maybe even a little bit higher than that. And so there are very active regulatory bodies there who ensure compliance. And lastly, a lot of this is viewed from an adult perspective, adult users of e-commerce websites. But there are specific laws, particularly CAPA, related to children and marketing websites targeted towards children and things of that nature. And if your website is deemed to be a child marketing website, the product you have is something that would likely be used by children. They come here for a game or something like that. Your privacy requirements are going to be heightened, and that's something to keep in mind as well. So that's touching on the website privacy policy, and now we're going to shift more towards our internal practices in developing an internal privacy program. This slide's really talking about setting that stage for your organization, how to develop that program, and really a little bit about implementing it as well. So firstly, when it comes to developing an internal privacy program, there's absolutely no need to reinvent the wheel. Don't sit there with a blank piece of paper and start drawing boxes and flowcharts on here's what we need to do. There are frameworks out there that are accepted both from a regulatory standpoint and industry standpoint. They would comply with the contractual obligations. Things like NIST or the CIS controls or other accepted frameworks that say, hey, this is what we use to implement our program. They tell you step by step. They ask you questions, you answer them, and then you address those risks. And if you show you've gone through that process, typically you're going to come out with not only a robust privacy framework, but one that's compliant with law and the expectations of your industry and your contracting partners. Part of this is developing that internal privacy policy. Again, that's that internally facing document telling your organization how you're handling data, where the data comes in, how it's stored, who has access to it. What's sensitive, what's not, how it's terminated, what do we do in the event of a breach? All of these things, if you lay that roadmap out and you test it, you really go through exercises with your organization such that they understand it. Again, great step to having that robust privacy framework. The next step is it really lends itself to John talked about earlier, and that's, an organizational buy-in and understanding of this. There needs to be accountability, responsibility. We laughed yesterday, a lot of times this falls to the CFO if there's not an internal IT person, but really there needs to be an identifiable, responsible individual who not only understands the program, but understands how it should be implemented and practiced by the organization. It's really important because there's, with any policy, whether it's an employee policy or this, if you have the paper, but it's not implemented and enforced, well, then you don't have a policy. You've gone through all this work to develop that. You have to enforce it at the organization level. And then this last point of data assessments, I think is something very important that's, often overlooked, but you can understand your risk profile from a privacy and data perspective by really just thinking through the process of how data is handled or how it comes into the organization, right? So if we're talking about an e-commerce website, we're receiving a lot of data from our website. Well, where does it go next? It comes onto our servers, it comes onto our systems, and then from where does it stay? On the internal infrastructure, go to the cloud. What assets have access to that data? Do we have company desktops, company laptops? Are employees accessing their emails via their phones? That really tells you where some of your access points and exposure is by what assets, what hard assets are actually locked into this data. And then how does it flow? Like we said, how does it come in? Where does it go? How do we process it? From a payment processing standpoint, we might outsource that to a third party, but then we take the shipping information and then we use that internally to get our product out to people or the products that the household's buying, things of that nature. And then what controls do we have in place to ensure that the data that our employees have is the data they need to do their business, to do our business, but not to misuse it in any manner. And then again, from a third-party contractual perspective, what obligations are we placing on our third parties, our software vendors, our freight, shipping, all those sorts of things? Are we placing any sort of contractual obligations on them to make sure that they're complying from a privacy standpoint? And then last, obviously, we need to make sure who's using our website, how, and what manner is that complying with our program. So from a practical standpoint, it's very important to know your industry, because you need to know what data you're collecting and then what data upstream and downstream is necessary, right? What do your suppliers have and what's coming to you from them? What are your customers giving you? What are they expecting in return? And then also understand the industry standards from this perspective as well, right? If you are if you're in the software industry, your expectations of privacy and data security are going to be higher than if you're in the manufacturing industry. And it's very important to understand that. There's also, like we talked about, your contractual obligations, confirming that your practices match your policies. Again, from an internal perspective, you might have that policy document, but if you're not complying with it, it's not a policy from a regulatory standpoint. And then also from the website perspective, if you're not complying with your policy, well, that could be an actionable item for a government regulator. And then also you need to develop a commercially reasonable information privacy program. A standard contractual term these days, it's been used frequently for the past 2 or 3 years, I've seen it often, is that your privacy program must be commercially reasonable. It must contain commercially reasonable technical, administrative, and physical safeguards. So all 3 aspects that are consistent with organizations of similar complexity and sophistication resources, right? So that last point's important because a small business with less resources is not expected to have the same privacy program as big tech, but it still must be commercially reasonable, right? And so understanding that nuance and understanding where you fall from a commercially reasonable standpoint is helpful in developing your privacy program. So John, I wanted to ask you, given all this, what is the difference and what do you see differently if you're developing a website for a business to business enterprise as opposed to a business to consumer one?
Yeah, so thanks, Justin. So as we approach e-commerce, we have our own path and strategy that we do. Typically, that'll start with personas. Who's your ideal client? What are they looking for? An example, a B2B client may utilize tools like a punch list, that they're buying products on a regular basis that they want to quickly and easily be able to go online and buy that with one click of a button and going in through login. Or they may have preferential pricing on 20 things, and that's what's important to them, right? So we're looking at who's your ideal client, and we're also looking at, what are your competitors doing in the space? many times as people look at e-commerce, they think, well, it's probably going to be the same interaction that I get on Amazon or some of those other things. And definitely as we look to B2C, it's, how do we get people to raise their digital hand, tell us what they wanted, what they're interested in, provide them with information based on data that we are able to collect, maybe not necessarily know who it is on the other line, but have some ideas based on some AI or data analysis that someone who likes this product probably would like this product, or this is a nice add-on to that product, right? Or how do we get that person back to the website more and more often? So, e-commerce it's a very general term, but definitely as you get in, there are nuances, things that can get very complex, more complex than picking the color and size of a garment. It may be a seal that's going to have to fit a specific part that if that comes and it's not correct, right, you've just shut down a manufacturing facility, right? So those are the things that, as we were talking about this in prep for today, Justin asked, then so what do you do when it comes into the privacy policy and those things? And that's where we raise our hand, not our digital hand, but we said that we're not lawyers, right? So that is why it's important to make sure that you're protected, not only from a technology and go-to-market perspective, but what things you should be considering, because just even that, if you happen to send the wrong part to a manufacturing facility and it shuts down the facility, that may be something that should be included in some kind of terms of use or something to cover you if that unfortunate event would ever occur.
Yeah, that's a great point. I mean, we often, if you're not e-commerce, just physical interactions and sales, you're going to have your purchase order terms and conditions, right? And it needs to be the same concept online. We all click through when we're buying something online, and we click, I accept the terms and conditions here. And it's a similar concept, and you can create that contract, contract between you and the customer that mitigates your risk just as much as you get the deal done. And then already posted terms of use can mitigate that risk as well, as saying that we're not committing to anything until you go through with the transaction on our website. You just don't try to get rid of as much gray as possible, make it black and white so we all understand where we're sitting. So we talked about a little bit, and this might be even a little more granular than before, but commercially reasonable safeguards, and here we'll look at technical safeguards. And some of this, relates to what we discussed before. So these are just a number of things you can do to ensure that your technical safeguards are up to par. Again, and John touched on it earlier, understanding your network, where the data is resting, how you have that structure, that architecture and an understanding of it really allows you to know where your risk is associated with the data that you're collecting. I know I talked about the data mapping, that assessment of understanding where the data comes in and then where it goes within the organization and then its life cycle. How do we get rid of the data? We talked about encryption of data at rest and in transit, and how that's very important, right? And so how we're keeping the encryption key off, or in a manner such that if someone gets encrypted data, they should not also have access to that encryption key. And again, I mean, typically, and John, correct me if I'm wrong, but encryption of data in transit is almost, I mean, if you're not doing that, that would be unreasonable. I mean, that is
correct. Yeah.
Controlling administrative privileges, and I'll touch on this a little later, but there's this concept where every employee or individual within an organization obviously doesn't need access to all aspects of the organization. That's particularly important from a technical standpoint. We really want to control who has the rights to our network and its architecture, design, and where the access is. And so controlling administrative privileges is important from that standpoint. Ensure the system in place can detect and respond to any breaches. Patching, I don't see it on this list, but you do the patches when they're pushed out from your software providers. And then enabling multi-factor authentication, again, another low bar that past 3 years, especially with the increase in remote work, multi-factor authentication is expected. It's not the exception any longer. And so we all have the ability to enable it. And so, I mean, we all know multi-factor authentication, it's in putting your credentials in and you get the confirmatory text, email, phone call to say that you are who you say you are. And it really just ups the bar on access to your system. And then regular testing is important. So from a regulatory standpoint, the idea of testing is mostly basically an annual requirement. I haven't seen anything higher than that, but you should at least be testing your system on an annual basis or reviewing the policy itself, right? I'm not saying you have to go out and get a third-party provider to do that penetration testing on your system. You can, don't get me wrong, but you should at least be going through the policy, reviewing it, updating it with the changes in laws that are required, and just ensuring that you're remaining in compliance and you still have that reasonable policy. And then table exercises. This is, you get people in the room and you just talk about what would we do? All right. So we have our policies, we have our paper. What would we do if X happened? And you talk through what your response would be, and how your program would be implemented. And that's very important to, not only ensuring that this would work in the unfortunate occurrence of a breach or an unauthorized disclosure, but it also, it gets your people comfortable with the concept, and, practice, helps them perform in the event something would happen. And in relation to that, there are often, we're seeing backups of systems, and John gets to talk about, how important backups are, and really the practical components related to those.
Yeah, so backups, and this really applies to both external systems. I say external to your organization, maybe that you're using a third-party web host or contractor there. In your internal systems, I think the same things apply, right? So making sure that you're doing backups on a routine basis, making sure you understand when you're doing a full backup. That may take a little bit longer, so it may require some downtime if it's a website of some sort. If you don't have the ability to do that without taking the website down. And then your incrementals, right? So the changes that happen every day. And how often do you store those incremental changes? Because what happens if there is a denial of access attack that brings down a server, or there is something that happens to a server that a hard drive fails, or a processor fails, or something like that. Your data is only as good as your last backup. Another thing that we're seeing a ton of is, when you're getting these people who are coming in and encrypting your data, right? And they're coming in and the ransomware, your last backup is your last regards on how many of the keys that they hold, right? So being able to have, within your within the network itself, how is that configured? So maybe you have a local backup, which is then duplicated to another local space, which is then sent online, which seems like a lot of work, right? But one may be inside of the network where a virus may have access. The other one is very specific on how it gets there. And then online, again, making sure that we're not overwriting data, and that we have it, 30 to 45 days worth of full backups, incremental backups. Again, so when these things could occur, or if they occur, that you have options and opportunity, as opposed to, which limits downtime if you're a website or e-commerce, and also downtime to your entire organization if it's something like ransomware.
Yeah, and ransomware, I mean, that process, if you do get hit with it, is you basically have to bring in a forensic analyst to find out where it came in, how long ago, if they can. And then you have to rebuild from that point. So if you don't have backups from predating that, well, then you really have to go through and rebuild the whole system, which would be a nightmare. I've seen the fortunate incident where a client got hit with ransomware and was able to find a backup that was unconnected to the server. So they were able to, switch it quickly. The ransomware didn't have access to lock down that server. And then operations were back up in, a few days. But I mean, if you have to go back through it and rebuild the system, you're talking about an extensive period of time where you might be locked out. And we're talking about, your sales systems, your employee systems, everything where you don't have access and you can't operate. So not trying to be scary, but backups are extremely important from that standpoint.
And this is one of those that unfortunately I've seen that people have the policies in place, but how often are you checking to make sure that they're actually happening, right? So making that's a routine, that someone is checking on backups, because the last thing you want to find out is in an outage for a website or in a ransomware thing that unfortunately the hard drive was full where your backups were going, or the disk drive was full, or just the job had failed. So this is definitely one of those things that are critical to, as you look at things that you can do to avoid, downtime or liability for your organization.
Next, we can touch on the commercially reasonable administrative safeguards. So again, this is your internal operations of your organization and how you're administering your privacy program and policy. And so again, we touched on earlier, you really identify the individual responsible for administering your program. And I joke that you see a lot of CFOs as this person because a lot of things fall to CFOs. But it doesn't need to be that person. If you have obviously an IT manager, it could be that person as well. But somebody with enough managerial authority that they can implement the program and an understanding of the system, so that they can make sure things flow smoothly. Again, second bullet point is training. It's really important to train not only on the system, but on the threats to the system. And we'll touch on that a little later as well. But things like phishing and how that can impact the risk to your organization. Record keeping is very important as well. And this is a small item, but as you implement the policy and then you change it from a year-to-year basis if necessary, having version control and understanding what we're operating under and what the changes were from a historic standpoint can demonstrate, the thought that you've put into your program and why it's reasonable and why we've changed things along the way. And that's helpful for keeping a healthy privacy framework. Again, risk audits on an annual and ongoing basis include assessing the risk of the current program and adjusting as necessary. You're seeing this more and more often with insurance coverage as well, requiring this sort of thing, not only requiring a written information privacy program, requiring multi-factor authentication, but requiring a risk audit on an annual basis. And so this is one level of compliance that you might not even have a choice in. To get that cyber coverage that you want, you'll have to go through with a risk audit. And then related to service providers, it's really vetting those third parties and making sure they have their own adequate safeguards as well. And the three that come to mind, cloud service providers, hard asset providers, and then your IT systems if that's outsourced. You have the right to ask from them the same thing that everyone might be asking from you, and that they have adequate safeguards in place, especially these service providers who have access to your sensitive data. John, from this standpoint, what do you see with respect to your clients in implementing the website policy organizational wide?
Yeah, so just like a website, we feel like the website to be the best representation of you, it should be living and breathing. And we believe that the privacy policy should be the same way, right? And leveraging third-party tools, we use TrustWave as an example that does all the scans and does all those things. And typically their report always comes back with something. Sometimes they're false positives. Sometimes, there are things and patches that you have to defend, justify, and explain. But it's just a good way to interact with our customer to show them that security is important. And with that, again, making sure that their internal and external policies are something that's living and breathing, because technology is moving so fast. We want to make sure that as you're, from a technology perspective, that, obviously responsive, all those things that you're presenting information where consumers want to interact with you, but also that you're doing it in a compliant way. So we suggest, just like your website should be a living and breathing extension of your business, so should your policies and your ongoing analysis.
Yeah. And lastly, the physical safeguards. And these are things I find that when it relates to privacy and data security aren't really front of mind, right? How we're physically protecting that data. One item is asset management. Like I said earlier, knowing where the data is resting, the hard assets it's sitting on, the life cycle of those assets, what happens to an asset when it's turned out. Do you wipe all the data? Do you wipe its access to everything? Do you destroy it? All of those things. Managing those assets. If an employee loses a laptop that has access to a network, well, that is a large risk for unauthorized access and disclosure to the data that you hold. So that's very important. Changing default passwords for hardware. So I'm not even talking just laptop, but Wi-Fi passwords, things of that nature. Stand in and of itself will protect against unauthorized access and use of data. disposing of information within a reasonable time period. So there are in every jurisdiction, specific laws that relate to data retention, document retention, how long things should or need to be stored for, or how long they should not be stored for. It's important to understand what data we have and if we're complying with those requirements as well. And then a simple one is also training employees and personnel to recognize abnormalities in their operating system, right? So if they're going through and on a day-to-day basis, there's a program running in the background that they're not used to, why is that there? Do they know to flag that to somebody in the data hierarchy who can tell them if that should be there and what it's doing or things of that nature? So as it relates to protecting against unauthorized access, I know one item that John and I were talking about is, former employees and, the access they did have and then do have post termination. So in relation to that, John, like what are some best practices to prevent, former employees from having unauthorized access to our data?
Yeah, so especially with the remote world, right? There's a lot of different things that people are logging into. So whether that is an Office 365, where there may be SharePoint behind it, or any of those accesses, just making sure that you have those policies in places that with a termination or a leave from the company, that those things are all turned off. And there's a good checklist, right? That may include the administrative passwords to your website, right? I mean, we all want to think that nobody wants to do anything malicious or do anything like that. And they may do things unintentionally if something got on their computer and still had that saved to a browser or something like that. So it really has those policies in place. Even, we suggest that, with Wi-Fi specifically, that you have that broken up in your organization, that if you're connected to the guest Wi-Fi, it has a more simple password, and really it's just getting you to the internet. But you may have some shared documents and shared resources within the organization that password probably needs to change as staff changes. If you can get your Wi-Fi out in the parking lot, then that means that they could too. Again, not saying that anybody's going to do anything maliciously, but it's just a best practice.
Yeah, and that's a risk mitigation, not only from the privacy perspective, but from the business perspective as well. You have your own confidential business information that you don't want to get out to a competitor or anything of that nature. And so, shutting off that access as quickly as possible is helpful to the organization. Yeah, we talked a little bit earlier about phishing concepts, and John, you feel free to run with this slide.
Yeah, I think related is phishing, right? And we're not talking about going to our pond in the backyard, right? These are those emails that look like they're from your organization, internally, externally, from your vendor, from your client. Really having a policy with your vendors from an education perspective, what you will and won't do via email. Things like changing your bank account, changing ACH information, changing wire information, so that they know that they sign off on a policy that if a phishing thing did occur and they didn't follow the policy, that maybe that limits your liability on something happening negligible. Also internally, right? Things that you'll do via email, things that you won't do via email. There's a lot of technical tools within the providers, the big ones, the Office 365s, the Gmails of the world, or third parties that you can get for dollars an email that will give organizational phishing things so that your IT administrator can kind of see things going on, and even personally saying that we've notified, even on the email itself. Always just looking at the from email, not what you can visibly see, but what the actual reply to and things like that before you just do an impulse move. There's things from a DNS perspective, which are things that are relative to your domain name, which can limit some of the phishing and help some of these tools, making sure that you have SPF records that are appropriate for any of the different systems that you're sending emails to. Internal tests, again, for dollars a month, you can have internal tests. We talked a little bit about the sensitivity of this, making sure that you are sending out things for the right interest and not something that could end up being something that would create a negative demeanor within the organization. I think, Justin, you shared one that they did an internal test that was download your holiday bonus statement, yeah. and that was a test, right? That may not go the right way within the organization. And within the education and policies, I strongly suggest that always have that, especially if it's financial, the verify in person or by phone. people are not only just doing blasts anymore, but I know of a situation where two business partners were communicating about purchasing a vehicle. And so somebody was listening, right? And so it made sense. Hey, I need you to go ahead and ACH this information over to the dealer, except for it wasn't the dealer, and the business partner wasn't the person who sent that request.
Yeah, I mean, the phishing attacks are getting more and more targeted all the time. I get them all the time, you know, daily basis. Attorney Molitoris, would you be interested in representing client related to this transaction? And there's telling things within a phishing email. Grammar's often wrong, incorrect spelling. If you look at the address from which the email comes from, there's usually something there that's a little telling. But it's really organizational education of, hey, you know, one, this is out here and know to recognize it. Yeah, and John's right. You know, those internal tests are great, but they do have they could create some negative goodwill if they are targeted in such a manner that, you know, the employees feel like they're, you know, sure they're being baited, but let's do it in a reasonable manner. I know from my own practice, I don't send things like, you know, the ACH wire information, anything like that via an unsecured email. So that either goes via secured email, fax, call confirmation, all of those things. Just because anytime I receive financial information from an unsecured email, I'm a little put off and a little concerned with it. So always verify. But when you send securely, you're putting the email into that multi-factor authentication world where, you know, the recipient has to confirm that they're the person who should be receiving the email. So you know, it's just another level of protection from the sending end.
So again, I mentioned earlier, passwords can sometimes be the weakest link. And we think about customer passwords too, or we started with customer account passwords, right? So, you know, having those simple checks to see, is this a weak password? Is this a medium password? Is this a hard password? Potentially running passwords against the databases and vulnerabilities and data breaches to educate your online users that their password has been compromised. A lot of the email providers, I think I just saw an ad for Google that they're doing some of these things for you today as well. Those administrative passwords, how often are you making those be changed? Again, as you talk about turnover of personnel, or just how strong are those? I mean, the last thing you want is a hacker to be able to come in and easily get to your content management system, publish pages that you don't know are there and utilize that in phishing, or, you know, put something that would be negatory about your organization. Your email passwords, again, multi-factor authentication is becoming more and more prevalent here to make sure that people aren't getting inside the organization. We talked a little bit about Wi-Fi passwords, again, making it easy for your guests to come in with very simple access, but, you know, making sure that you change those as you have employee turnover. And then, you know, really monitoring yourself. There's tools like I've Been Pawned with no A there. You know, I've been using my email address since 2001, and I've been part of just going on here 37 breaches, right? So if I was one of those people, and I was at one point early on, we use the same password on different websites. I've just given the keys to the castle to those hackers, and that's exactly what they're looking for. So a lot of different things, whether you're a third-party password generator person, those tools continue to become more complex. Or however it is, just it really is one of those things that, yes, we have a lot we have to remember, and where it's an abundance of continuing to use these things, but it can sometimes be the weakest vulnerability for an individual person or the organization.
Yeah, and I clearly don't use the same password for everything. Don't write down your password on a sticky note and tape it to your desk right beside your keypad. You know, those are the low bars. But I mean, things like, password generators, password managers are becoming more and more robust and accepted. I would suggest using, if you are using password managers, you know, those employer provided ones, I think should, you want to be in, you know, employment related passwords. People can get personal password managers for, you know, their Gmails, their Amazon accounts, things of that nature. But again, you know, password integrity and complexity, a low bar that, you know, it really heightens your protections. You know, the more complex your password is. So here's some more best practices just related to organizational privacy programs and things of that nature. You know, from a high level view, taking an intentional approach, puts you ahead of the field, right? Really looking at your program and how, your organization needs it to operate. And revisit it each year. Encourage all enterprise buy-in from all your employees, every level, because everyone has access and impacts this. Anyone who has access to your building that can access your assets has access to the data. And so we need to have an understanding of how those, how that all plays into the program. The principle of least privilege is something I touched on earlier, but I want to revisit. And that's this concept that not everyone within an organization needs access to all the data that you have, right? A certain employee's role means they should have access to this limited set of data and be walled off from other data. And there's ways to structure your network to do that, such that if someone is compromised in this silo, it doesn't impact this other world of sensitive data, and doesn't impact your efficiencies from an operational standpoint as well, right? The employee needs to have access to the data they need to conduct their job, but doesn't really need anything more beyond that. Third-party cybersecurity risk assessments, again, we touched on earlier, are helpful. From an operational standpoint, data classification is important as well. All data that we have is not sensitive data, right? There's directory information, essentially phone book information, that it's out there in the world regardless. No one really has an expectation of privacy with relation to that data. But then there's very private data. We probably have our employees' social security numbers, banking information if we have payroll in-house, things of that nature, which is highly sensitive and needs to be protected in a different degree than directory information. Multi-factor authentication, again, very low bar. Please, enable it. We all have the ability to do so. Train regularly. Require passwords, strong passwords, unique passwords that are changed on a seasonal basis or so, and enforce the program, right? Again, having a piece of paper out there doesn't do anything if we're not implementing it organization-wide. And frankly, it could be a red flag if you're not implementing organization-wide, right? If there is an incident and you had a plan and you didn't follow it, well, why is that there if you're not going to use it? So again, these are some low bars that really can make for a robust privacy framework. Looks like we have some time for questions if there are any questions from the audience.
I see there might be one question in there. So Amanda says that they use Wufoo as a primary e-commerce software, and other web-based companies like Constant Contact for marketing. After we purge old data from these types of accounts, do these companies keep this data on their servers? Do we have any further responsibility once we delete data? Can we be held liable for breaches at those types of companies? And there's also a second question, or another question after that.
Yeah, I'll start and then let John step in. One, obviously, their practices of their retention of information, your third parties, it's really dependent on your agreements with them, right? I mean, what have they committed to do contractually, and do they have the right to retain that information? Do they have it on a anonymized basis? When we're talking about your responsibility, have you disclosed that this information could be shared to companies like Constant Contact, to your users or your customers? And to what extent is that is the notice to your customer enough, right? I mean, do you tell them why you're using it, who has access to it, for how long? And then do they have access to the data on an identifiable basis, right? Do they have, the ability to link data to a particular individual? Because if not, if it's anonymized, de-identified information, your risk profile is mitigated and it's much lower. It just depends on whether or not they have access to anonymized or identifiable data.
Yeah, I mean, I would agree with that. I think it's more the policy with them. I mean, both of those organizations, I doubt are going to do anything malicious. There's probably something in their terms of agreement that says what they're going to do with data. The other thing I would just also voice is, after you purge old data, what does that mean, right? Are you downloading a CSV? Are you, once you've deleted that information, making sure that you're not storing that anywhere or in an unsecure or unencrypted method? But that's probably going to be something, and I would imagine that if they have the right privacy policies in place, they probably have someone that they can go to ask that specific question.
Yeah, certainly, certainly. Do you recommend passwords be stored internally, Excel spreadsheet, for example, or a web-based program? I would say no on the internal storing, because think about what that exposure looks like if there was unauthorized access, right? If somebody had access to your system and was able to get to an Excel spreadsheet that had passwords for X, Y, and Z, how far could they move horizontally and vertically within your organization, right? Whose passwords are they? What systems are they linked to? What data would they have access to? So anytime that we're writing down these, whether it's in a hard copy form or online, it increases our risk profile. The password managers are great programs that are considered to be more and more robust these days. And it's a third party that provides the storage of your passwords. And so your credentials are linked to your stored passwords. And so that third party is taking on the risk of making sure that those passwords aren't accessed by other people. That being said, there is a convenience concern there. Oftentimes if an employee has been terminated and they have all their passwords saved into a password manager, and hey, that includes their personal passwords, well, we're going to shut off their access to those passwords, right? They don't get to use our password manager after termination or a voluntary termination even. And so from a convenience standpoint, there's that concern. But from a risk standpoint, yeah, it's best not to have those things written down anywhere.
Yeah, and it also, I mean, when you're using those third parties, that's where that encryption's coming in, right? Your Excel spreadsheets aren't necessarily, they're probably not encrypted, probably not even password protected. And some of those can be pretty easily uploaded to a website to break some of those basic password things within Excel. So definitely, as you talk about best practices from specifically technology perspective, it is that the liability is being moved to that third party, and they are storing that in an encrypted manner. So if there was a breach, in theory, they wouldn't know what your passwords are.
And then Ian would like to know, what do you think of cyber liability insurance? Are they reliable and essential for most small businesses? Any recommendations on good resources for this type of insurance?
Sure. And, the short answer is yes, I think they're essential for most small businesses. I think your typical commercial insurance broker will have access to the right policies here. Are they reliable? Yeah, depending. It depends on, every policy has certain exclusions and exceptions. And implementing a written privacy policy, a commercially reasonable one, has been the bar recently. Multi-factor authentication, those sorts of things. If you have these in place, it's more likely you'll have coverage. And continuing to maintain a commercially reasonable privacy policy is very important. And again, acknowledging that that's ever changing. And that's ever changing both from a legal perspective and in the insurance world. So cyber liability insurance has been getting hit a lot, as you can imagine, in the past few years. There's more ransomware incidents all the time. You see them in the headlines. And so that means that that insurance product is paying out when there's coverage. And so premiums have gone up. But with that there's heightened requirements to getting coverage, which I think are great for your organizational health. If you go through these processes and you develop a commercially reasonable privacy program, then it's more likely that if there was an unfortunate incident where you got hit, you'd be prepared to respond to it. Now, I do want to touch on one specific exclusion. So there's a list of state actors in the world who are deemed to be terrorist friendly or terrorist sponsors, which are often excluded from cyber liability insurance, right? They're saying if there's an insurance claim and it's caused by a state actor or a terrorist body that's on this list, that we're not going to cover it. You can get a rider to get coverage there. Very important to do so. All right, because I've heard from third-party providers of incidents where an organization had cyber liability insurance. They got hit. They thought they had coverage. It was deemed to be a state actor. They did not have coverage, right? So either you have the capital to recover from that on your own, or you don't. And then what does that look like? So ensuring that you're covered in the event of state-sponsored cyber activity is very important to ensuring that you have a a cyber liability insurance policy that covers your organization.
Great. Well, I think that's all the questions we have open right now. So thank you very much for the informative information and presentation that we had today. I hope everyone got a better understanding of what's required of businesses to protect their customers, to protect themselves. Interesting information about backups and so much information that was in a great presentation. So if your question didn't get answered during today's event, Barrett McNagny has graciously agreed to respond in a follow-up email to everyone who registered today. We'll send out the video to everyone who registered, so be on the lookout for that. If you would like to view previous Business Weekly webinars, submit a topic you'd like us to cover, or find out how you can become one of our presenters, visit us at www.kpceventbuzz.com/webinars. The webinars are free for Business Weekly subscribers. Non-subscribers will pay a small fee. Our next webinar is going to be September 8th. It's going to be Premier One, an alternative solution to employee health insurance. And is there anything else that you'd like to mention, Justin or John? So.
No, just thank you for all the participants. Lisa, thank you. And thank you to Greater Fort Wayne Business Weekly.
Ditto.
Okay. Great. I want to thank you both again and have a great day, everyone. Thanks.
Thank you.